Got questions here asking if a landlord has to provide a microwave, a dishwasher, an air purifier now under habitability standards under California law. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, subscribe to our videos here. Now, I don't know if this question was being facetious or not. I know I've been talking with a lot of landlords lately about the new refrigerator and stove requirements now, and a lot of people are talking about other items, AC, that type of deal. We might talk about that in a separate video here because LA County had passed an ordinance recently for units within the unincorporated parts of the county that I guess they have to keep their units under like 85 degrees or something like that. So hence air conditioning is mandatory, but would there be a state push? We'll talk about that later on. But to answer this YouTube TikTokers questions about the microwave and the dishwasher and air purifier, the answer is no. Under current California habitability standards, none of these items are required by law to be provided to a tenant, although in many cases most of the units I deal with have at least a microwave being provided. It's like built in, like above the stove. Those have been pretty common. Dishwashers, that's kind of like 50-50. And an air purifier, I don't know if they have those built in or not, but usually that's usually like an appliance that you would bring yourself as a tenant. So the answer is no. Under state habitability standards under Civil Code section 1941.1, none of these items are in that code section as at this time right now that are required to be provided by the landlord. These would be considered amenities, if they were provided by the landlord. And like I said in a couple of other videos before, if you do provide something as a landlord under a written lease agreement, you might be responsible for maintaining that under contract law, not under state habitability standards, because in a lot of leases, if something is provided by the landlord, the lease term does say that it's usually maintained by the landlord. You could have specific clauses for amenities that if it is provided, those items won't be maintained by the landlord. It will be up to the tenant to maintain them as to amenities. But for habitability items, like water heat, hot water, that type of stuff, that's usually on the landlord to maintain under state law for habitability standards. So hopefully that answers that question. Landlords, if you are facing a situation where you have a problematic tenant situation, the tenant's not doing what they're supposed to be doing, or not paying their rent, and you're in the Northern California area and you need help, feel free to reach out. You can go to my profile and it will take you to their website, and you can book a free case review so we can see if we can help you out. A couple of questions we asked to see if we'll be a good fit or not. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.